I have to say I was a little nervous when I heard my wife was going to introduce me. She knows too much.
Tilt it up.
Okay. Also, I don't know what I think of being asked to speak when I should be eating, but I'll be fine. There's a lot of familiar faces here, a lot of people that we know, a lot of pastors that we know, people that lead organizations that are advancing the cause of Christ. And so I want to welcome them and everyone to our farm. We really appreciate you being here. We all have the same Lord, and we all have the same cause here. And I'm just excited that we're able to gather and to talk about these issues. And I want to thank Alex and Kim for your thoughts today and for your ministries. We really appreciate what you're doing. I'm going to take a little different approach than they did, and then I'm going to be talking a little bit about the law, but I'm not going to be getting into a lot of details, and hopefully this won't be, I won't get lost in the details of the law. What I want to talk about is how you can use constitutional rights to change laws and to impact government and public policy. You know, we live in an age where government is enacting laws, school boards are adopting policies, and they're imposing regulations that are increasingly anti-Christian. And they're contrary to the teaching of the Bible. I'm not talking just about communist China. I'm talking about the United States. I'm talking about changes that are taking place that I never would have imagined when I was growing up, or even as a young adult. These things that are happening now were not happening then. And I think we need to wake up and really take these things seriously. Our Constitution gives you rights that you can use to stand up for your faith and to stand against laws that are against our faith and that are against the teaching of the Bible. And I'm going to talk about 4 ways that you can do that, and I'm going to talk about it in the context of 4 legal cases where Christian advocacy was tested in the courts. And then I'm going to end by talking about 501c3 organizations and what a 501c3 organization may or may not do that could jeopardize its tax-exempt status. I want to start, though, with the words from Jesus in Mark chapter 13. If you have your Bible, which you probably do because you have a cell phone and your Bible is on your cell phone, you can read along with me, but it's in Mark chapter 13, starting in verse 33. And this is really significant to me because the last words of Jesus in this passage are followed by an exclamation mark. So I kind of see him grabbing the lapel of these disciples, 4 disciples that he's with, and he's saying, "Listen to me, I'm serious, this is important." And starting in verse 33, he says, and he's talking about the coming persecution of his followers. And he's talking about his second coming. And he says, "Take heed, keep on the alert, for you don't know when the appointed time will come. It's like a man away on a journey who, upon leaving his house, putting his slaves in charge, assigning to each one his task, and also commanded the doorkeeper to stay on the alert. Therefore be on the alert, for you do not know when the master of the house is coming, whether in the evening, at midnight, or when the rooster crows, or in the morning, in case he should come suddenly and find you asleep. What I say to you, I say to all. Be on the alert."
Yes.
So Bev, she's on the alert. Alex is on the alert. Are you asleep or are you on the alert? Are you a slave doing what our master, Jesus, is telling you to do? It says here that he gives us tasks. He gives us assignments. He says, are you doing your task? Are you carrying out your assignment? or are you going to be like the one that's asleep? So this is a call to all of us to be on the alert. And I want to talk about 4 stories about Christian men, women in ministries who were assigned tasks to take a stand for their faith and stood on constitutional rights to change our laws. You know, Alfred started us off talking about what one man did, you know, as against the empire of Egypt. What did one man do? There's just a lot that one person can do. Now, the first constitutional right I want to talk about is the right to petition the government. That's guaranteed by both our federal constitution and by our state constitution. I want to take you back to 1992. And in 1992, in Tampa, there was legislation passed in the city of Tampa to enact or to put sexual orientation into our anti-discrimination laws. And this was a big deal. I don't know if you were around at that time, but in 1992, there was this law that was proposed, and there were public hearings. And the Performing Arts Center was packed. I mean, the very largest auditorium was completely full, and there were people waiting at the door wanting to get in. And these people were coming to speak to City Council about this and to let them know what they thought should be done and why. And by far the vast majority of these people were Christians who were coming in speaking against the passage of these laws. The City Council passed it anyway, notwithstanding this overwhelming opposition. So what happened was an individual, Richard Cluis, and some others formed a committee called the Take Back Tampa Committee. And the purpose of the committee was to get a ballot measure, a referendum, put before the voters to vote on whether or not to repeal this sexual orientation law. And they did it with a petition. So they circulated this petition, they created this petition to put this on the ballot, and they circulated this petition. And they gathered all the signatures that the law said that you needed. However, that was not the end of the matter. The supervisor of elections, Robin Kravanik, found a way to interpret those laws in a way that she excluded 462 signatures, which is just enough to keep it off the ballot. So I was hired by the committee to file a lawsuit to ask the court to compel her to count the signatures and to put it on the ballot. And so that's what we did, and we argued the right to petition the government is a right guaranteed to us by the constitutions of both the state of Florida and the United States Constitution. And so, since it's a fundamental right, it's a fundamental constitutional right, the laws regarding the process of petitioning ought to be liberally construed in favor of the complete exercise of that right. And we argued that the supervisor interpreted the laws in a way that were contrary to that exercise. So the matter went before the judge. It just happened they're assigned by blind rotation to the chief judge of our judicial circuit, Guy Spicola, and he, in a 13-page opinion, agreed with all of our arguments. And he said that what she had done was improper, and he entered what's called a writ of mandamus, compelling her to accept those signatures and to put them on the ballot, put the referendum matter on the ballot. So now an entirely different battle began. Well, let me say one other thing. The supervisor immediately appealed that to the Second District Court of Appeals. The Second District, and something that I think is somewhat unique, adopted his opinion verbatim as their own and said, yeah, this should be on the ballot because those signatures should have been counted. So then this other battle begins, and that's the battle on the referendum. And so the committee put out these flyers that said simply, sodomy is not a civil right. And at that time, it wasn't. As we all know, since then, the U.S. Supreme Court, Justice Kennedy from California, wrote the lead opinion on this, and he said, the controlling opinion, he said it is a civil right. It's not in the Constitution, but like the right to abortion that they found in 1972, they somehow found this right. But in 1992, it was not a civil right, and so the committee put out information about what was really behind all this, and that this was part of a national agenda to advocate gay rights, and that this was just the first step, and that the next step was going to be recognition of homosexual marriages, and then gay adoptions, and then putting homosexual teachings into the school system. And so the opposition committee was called Say No to Hate. And so often these organizations that are trying to advance these anti-Christian, anti-biblical agendas just resort to labeling, and rather than engage in a real discussion about the merits of the issue. And so everybody that disagreed with them was labeled a hater and likened to Hitler, and this was, like we're slave owners, and doing everything they could to demonize the people on the committee, anybody who voted to repeal this. And so, the matter was on the ballot. The people spoke, and it was repealed by about 60% to 40%, which is considered a landslide. So that's not the end of the story, though. Meanwhile, she appeals to the Florida Supreme Court, which takes some time, even though it's already gone before the voters. And now the petition kind of doesn't matter. It's like the voters have spoken. There was no issue about the legitimacy of that election. Yet she appeals to the Florida Supreme Court. I was in Tallahassee arguing this, and I could tell I was in trouble by the questions that were being asked, the comments being made by the Supreme Court justices. And at that time, the Florida Supreme Court was considered to be very liberal. So the Supreme Court ends up reversing some question about whether or not it had any effect on the election. But that didn't matter also because the city council members who put this into law were all voted out by that point. And a new city council was in that made sure it was repealed. But the Supreme Court said, we think that the supervisor of elections ought to have the discretion to interpret the laws the way she thinks is appropriate, so long as it's not unreasonable. So that's not the end of the story either. So that decision as to the Court of Appeals was reversed. Now jump to the year 2000, and we got a presidential election between George Bush and Al Gore. And in Florida, there was a lot of controversy about that election process. You all remember hanging chads. Mm-hmm. And so, Gore lost, and he challenged what the supervisors had decided regarding these hanging chads, and he said, you should not have counted all these ballots for Bush, and I want a manual recount. Well, he lost. It went up to the Court of Appeals, and it ends up in the Florida Supreme Court, and they said, we agree with Gore. We believe that the supervisors got it wrong, and there's going to be a manual recount. Then George Bush appeals to the U.S. Supreme Court in Bush versus Gore, and it goes in front of the U.S. Supreme Court, and they reverse. And what case did they cite to knock down what the Florida Supreme Court was doing?
Their own.
Kravanek versus Take Back Tampa, where the court said, we got to defer to the supervisor of elections. And the U.S. Supreme Court said that you wrote in Kravanek versus Take Back Tampa that you're supposed to defer to the supervisor of elections. Is it a reasonable interpretation? Based on that decision, Supreme Court of Florida, you're wrong, we reverse. So look at what happened based on what one guy in Tampa did. Okay, that's on the right to petition. Now, another right we have is the right to boycott peacefully. And so I represented the Florida Family Association, and we ended up in court. This time, we weren't the one that initiated the lawsuit. We were responding to the lawsuit. And the lawsuit was brought against Florida Family Association by Penthouse, Playboy, any pornographic magazine owner was suing Florida Family Association. So what did they do that got them so enraged that they filed this lawsuit? And in the lawsuit, they were saying that you committed criminal acts and you were guilty of RICO, that is racketeering violations. So what Florida Family Association did was it wrote letters to convenience stores and other places that were selling the pornography, and they said, this is harmful to our community, and we want you to pull the magazines and not sell them. Not just hide them under, not hide them under the counter, just don't sell them. And they said, now if you do, then we're going to write to all of our subscribers, which is a very large list of subscribers, and we're going to tell them to boycott, to not buy anything from you, don't buy your gas, don't buy anything from you. Well, this was very successful, and a lot of these stores and convenience stores pulled the pornography, and that's what caused the lawsuit, was because it was hurting them in their pocketbook, which is what it was designed to do. So they exercised their rights to a peaceful boycott. So I was hired to defend in court what they had done. Well, the U.S. Supreme Court says that if you peacefully boycott, that is protected political speech. And on the basis of that Supreme Court authority, we were able to get that lawsuit thrown out. But you know, this combination of Hobbs Act says that you're not allowed to extort, or you're not allowed to conspire to extort. And then the RICO would be repeated violations of the Hobbs Act. That's used often by the abortion clinics to go against abortion protesters, saying what you're doing is extortion and violates RICO. If nothing else, they try to create a fear of going against them because you're going to be facing these lawsuits. I'm telling you, we have the right to boycott, to peacefully boycott. That's another right that we have. Now, a third one is the free exercise clause in the First Amendment, free exercise of our religion. We have that right. And we also have the right of freedom of expression guaranteed by the First Amendment. And in this case, the owner of a small bakery in Colorado, and you probably are familiar with this, a devout Christian refused to bake a cake to celebrate the marriage and the wedding of homosexuals. And he said, I'll make you a birthday cake, I'll make you any kind of cake you want, except I'm not going to make a cake. And this baker was very artistic, had a very popular bakery, and he said, I'm not going to use my talents and artistic expression to celebrate something that is antithetical to my Christian beliefs. Yeah. So they reported him to the Colorado Human Rights Commission, and they said that he was discriminating based on sexual orientation. And so there were public hearings held in which he was called before them to speak in public about the stance he had taken. And he was, by the commissioners, he was called hateful, he was likened to a slave owner, he was likened to Nazi Germans who were putting Jews in concentration camps and murdering them. This guy stuck with it though, and of course he lost there. And they said, yes, you violated the sexual orientation law. And when you first hear about these sexual orientation laws, you think, well, you're not, what would be wrong with saying you can't discriminate based on sexual orientation? But these are used for so much more than that. They're used to impose an agenda and a lifestyle. And what Take Back Tampa said in 1992 has turned out to be true. It's being used to try to normalize sodomy throughout our nation. And now it's pretty much accepted in our culture because of it. So it works its way up to the U.S. Supreme Court. The U.S. Supreme Court says, they reversed, but I think on a narrow ground. And it was because of the way the proceedings were held. And they said, you know, government has got to be neutral when it comes to issues of religion. And this government was extremely hostile. And they cited what I just said about saying you're hateful and you're like a slave owner and you're like a Nazi killing Jews. And they said that's not neutrality, that's hostility, that's hostility. And they ended up reversing, and they said he had the right to decline to express himself through a cake that endorsed a practice that went contrary to his deeply held religious beliefs. But I bring the case to your attention just to show you this is what one person did, you know, to change laws and to change culture somewhat and to change public policy. There's another one that involves an association, and this one was in California, and it was a group called the Fellowship of Christian Athletes. And many of you may know about it, many of you have been involved with it. I know Nancy and I have for many years, and so it's a national organization. And in California, the school district in San Jose shut down the FCA chapters and said, you cannot meet in our schools. They just denied them any status rights at all to participate with all the other clubs, you know, in the schools. And why did they do that? It's because the leaders of the local huddles were required to sign a statement that said they commit themselves to sexual purity between a man and a woman within the confines of marriage, and they had to affirm their belief in the Christian faith. Now, this was not a condition to come to a huddle meeting or to even join the group. Anybody could, regardless of your faith or belief or your thoughts about sexual purity. But if you wanted to be a group leader, you had to sign that. Well, the school board thought this was outrageous. This is like Nazism. This is like slavery again. All the same stuff. And they had these hearings, and then they said, we cannot allow this because this clearly is targeting homosexuals. And so what you're doing is you're saying that homosexuals cannot lead your huddle group meetings. And they were outraged by that. And they said that this also violated the school board policy of inclusion and tolerance by excluding students who had other religious beliefs. Which, all that sounds pretty outrageous, but to make it even worse, the school board was allowing other clubs to exist and meet that limited membership based on sex, gender, and religious practices. For example, listen to these other groups that were allowed to continue to do what they did and to meet on school property. The Senior Women's Club. Now, the Senior Women's Club is limited to high school seniors, you're in your final year, who identify as female.
Yeah.
So these are primarily guys who think and identify as females. They're allowed to continue to meet. If you don't fit in that group, you're not even allowed to join. I don't know why anybody would, but you would not be allowed to join. The Gender and Sexuality Alliance Club, and you can imagine what that's all about. They're allowed to continue meeting and to exclude people who don't fit the criteria of their club. And get this, the Satanic Temple Club, permitted to go on meeting. You know, our kids are not in high school anymore, and I'm a little bit out of touch about what's going on in the schools, but when I read these cases and I read about what's happening, it's really shocking to me. And, you know, I remember back in 1992, the Take Back Canada Committee, they kept warning. They said, you know, they're going to target children. and they're going to try to indoctrinate children. You know, when you get them at a very early age and they're taught these things, by the time they're adults, they're going to usually act consistently with that. And it's a lot of the activity that concerns me is all taking place in schools. And they're really going after and targeting children. And they're taking a long view. You know, they're like willing to wait. Think back to 1992, it's been more than 30 years ago. You know, we've got whole generations of people that have grown up now in a different culture than we have because of these sexual orientation laws. So that's what's going on legally. But there are things that we can do that are, there are actions you can take that are guaranteed to us by the Constitution. That, you know, you've got to go through a lot. You got to stay with it. But now is the time, as Bev said, now is the time. Now, what can a pastor say, or what can the church do on these types of issues without losing their tax-exempt status? Well, a lot. There's a lot you can do. Okay, so the so-called Johnson Amendments passed in 1956 talk about limitations on what a tax-exempt organization can do to support or oppose a candidate. Okay, but not an issue. So all the things that I just talked about, the church, any organization that's a tax-exempt organization, they could have done all of those things and their tax-exempt status would not be put into question at all. The issue is with advocacy for or against a candidate for public office, not with advocating for or against an issue. Now, as with most things in the law, you know, when you look at all the details of each individual case, it can get a little muddy at the edges of those two opposite ends of the spectrum. Let me just talk about a couple of things that, a couple of issues that help us to understand more what all this means. First, you got to distinguish between the tax-exempt organization and people working in the organization. So let's say Alfred, who is very active in his community, goes to a rally for a candidate for office. And he says, I support this woman or this man, and here's why I support him. Is his organization, is his tax-exempt organization jeopardized because of that? No. Now, if he goes out there and he says, you know, on behalf of everybody that supports my organization, we support this candidate. Now he's advocating on behalf of the organization for a candidate or against another candidate. So what he can do personally is different from what he can do in his capacity as the leader of his tax-exempt organization. If it's a church and you come in, you invite people in, and you say, I endorse this candidate, or here's why we ought to get behind this candidate, and it takes place on church property, now again, you're in trouble, because now you're using the tax-exempt organization to advocate for or against a candidate. What about holding a press conference off campus? And he goes out and he tells the press, you know, he's well known in his community, and he wants to help out this candidate. He can hold a press conference and endorse the candidate. But if he ties it somehow to his church, then, you know, you're getting into an area where you're going to get into trouble. What about get out the vote activities by your organization or by your church? Can you set up a table in your church and try to register people to vote? Absolutely, you can. Can you do it and tie it to a political candidate? No. You can tie it to all political candidates, but not to a political candidate who you support. What if you go out and canvass your neighborhoods, your volunteers go out, canvass the neighborhoods, and they ask about your view on some issue, maybe you know, books in the public libraries, whether or not they should be exposing young children to, sexually themed books and things. And if they say, yeah, I'm against that, then you say, okay, well, I want to encourage you to register to vote. Okay, and then you tie that into a candidate. That's a problem. I mean, that is a problem. If they say, I am for that, and then you just walk away and you don't do anything to encourage them to vote or to help them learn how to vote, that also could be a problem. Okay, because you're now getting into advocacy for or against a candidate. Public forums for candidates. You can organize and sponsor them. Like here, you can organize and sponsor a public forum for a candidate to come and to speak, so long as you don't do it in a way that promotes or endorses one candidate over another. Give everybody an opportunity to speak. Now, it could be a gray area if you give everybody an opportunity to speak, but you're controlling the process and you load all the questions through biased questioning to favor one candidate versus another. The IRS regulations say that could be a problem. But if you invite a candidate to speak at your banquet or event, is that okay? Somebody who's running actively for political office, and I'm talking now again about 501c3 organizations and tax exemption. I want to make clear that anybody can speak on any of these issues or on any of these candidates. That's not the issue. The question is your tax exempt status. So can you invite them to come and speak when they're a candidate for office? Well, if they come and they help you raise funds, yes. If they speak about an issue or issues that are important to you, yes, that's okay. The candidate makes a campaign speech. You can't do that. You're running into problems now because you're helping to endorse a candidate for public office. What about, we've talked about promoting and opposing political issues. As I said before, you can do that. You can, as a 501c3, you can promote or oppose different political issues. But if you start tying it to a political candidate, I think that abortion is wrong, and candidate Smith also agrees abortion is wrong. Candidate Jones disagrees with us. I think you know who to vote for. Now you're involved in endorsing candidates, so that's a problem. How about advocacy on your organization's website? Well, obviously, all these rules apply to a website. You can't put something on the website that you're prohibited from doing through traditional means of communication. What about links on your website? What if your website has a link to a particular candidate's website? Is that okay? Well, if you provide links to all the candidates, you're just trying to inform people who are interested in your church, who's out there and who's running, that's not a problem. But if you just provide links to the candidate of your choice, then that is a problem. What if your site contains an article in favor of an issue, and in the article you link to a website of the candidate where the candidate writes in favor of your issue? You've probably crossed the line. Okay, now, what about using contributions to your 501c3 for advocacy? Is that okay? Well, obviously, if you use the contributions to your 501c3 to contribute to a candidate's campaign fund, that's a big problem. You can't do that. Can you use those contributions and take out an ad on the internet advocating a position on an issue? Absolutely. Yes, you should be doing that. Can you use contributions to donate to another organization that actively supports or opposes candidates? No, you can't do that. Can you make your facility available, say your church, for free to a candidate for an office? Only if you make it available for free to all the candidates. So all these cases are decided on a case-by-case basis. Keep in mind, relate to keeping your tax exempt status, you're not prohibited from doing any of these things. The law emphasizes that. The issue really is, should the government, through a tax exemption, essentially subsidize advocacy for or against candidates for office? And the answer is no. The answer is no. Now you might be thinking, okay, I violated this. Am I going to lose my tax exempt status? And the answer is probably not, because the IRS has not been very active in going against 501c3 companies or organizations and changing their status and saying you've lost your tax exempt status. But it's all a matter of degree. You know, I've heard about people driving 60 in the 55-mile zone. I've even done it myself. And in front of a policeman, they don't get pulled over. But if you go 90 through there, you're going to get pulled over, and you should. So, you know, it's a matter of degree. If your organization is being used pervasively to support or oppose a candidate, I think you've got problems. And you should not be doing that. And there's an alternative. It's not hard to set up an entity or some kind of a committee or organization whose purpose it is to endorse or oppose political candidates. But it just won't be a tax-exempt organization. You can still do it. You can still get people to donate. And so that's what you ought to be doing. Don't use your 501c3 to support or oppose candidates. Bottom line on that. But by all means, I encourage you to do it on these issues that are so important to us.
Yeah, come on.
And the final word I would say is pray about everything, okay? Pray about everything. Seek godly counsel, and by all means, be on the alert.
Amen. Come on.
Amen.
Thank you.
Yeah.